On behalf of Children and Family Futures and the Family Drug Court Learning Academy, welcome to our webinar presentation. Special thanks to the Office of Juvenile Justice and Delinquency Prevention, who supports the National Family Drug Court Training and Technical Assistance Program. For more information about Children and Family Futures, the Learning Academy, and the Family Drug Court Training and Technical Assistance Program, please visit our website at www.cffutures.org. We hope you find this presentation helpful as you strengthen your partnerships and improve outcomes in your family drug court.
Hi, my name's Mimi Laver, and I'm the Director of Legal Representation at the American Bar Association Center on Children in the Law. On behalf of the Family Drug Court Learning Academy and the Quality Improvement Center for Collaborative Community Court Teams, I want to welcome you to this presentation on why high-quality legal representation matters to families affected by substance use disorders. Since 2006, I've directed the National Alliance for Parent Representation, and I'm also a lead attorney for the Family Justice Initiative, also known as FJI, which is the partnership between the ABA, Children's Law Center of California, Office of Public Defense in Washington, and Casey Family Programs. We launched the FJI in 2016 with one unified goal: to ensure every child and every parent has high-quality legal representation when child welfare courts make life-changing decisions about their families. A parent's right to raise his or her own child and a child's right to be raised by his or her own parent are fundamental liberty interests protected in this country. A parent is presumed to be fit. And yet, approximately 400,000 children are separated from their families each year and placed into foster care. Unfortunately, nearly half of those children never return home. Rather than finding safety, these children are disproportionately affected by the negative impacts of mental health issues, substance use issues, poor educational outcomes, incarceration, and further victimization. In light of the traumatic consequences of separation, it's shocking that many children and many parents either have no legal representation or inadequate legal representation when courts are making really important decisions about their families. Whether a parent or child has high-quality representation is contingent upon where they live, what county, what judicial district, or what state. It seems to me to be incredibly unfair that your outcomes in your child welfare case and in your court case are contingent upon where you live. Families deserve more, both because the liberty interests at stake are extraordinary and because high-quality legal representation has been shown to positively impact a family's outcomes in their child welfare case. Family treatment courts generally operate with the mission of reunifying and keeping families safely together. Attorneys play a key role in accomplishing this mission through advocacy for the parent and children. If your team is committed to reunifying children and safely keeping families together, then attorneys who use reasonable efforts arguments as a tool and zealously advocate for their clients by holding the system accountable can help you reach that goal. Recent studies have showed children and parents with high-quality legal representation have fewer unnecessary removals and are more likely to have frequent family or parenting time, participate in court hearings, engage in meaningful services, minimize time in foster care, achieve permanency sooner, and have their families reunify successfully. And all of this does translate into system savings, which may not be the most important piece, but is an important part of making a pitch for high-quality legal representation. All of these outcomes improve child and family well-being. Family well-being and taking a more family-centered view are fundamental to this issue. We know that the fields of substance use treatment and child welfare have evolved by taking a more holistic view of recovery and safety, and the movement of high-quality legal representation is following suit. Historically, legal advocates in the child welfare field have focused on the value of representation for children or for parents. What is lacking is a unified agreement about the importance of high-quality representation for all parties. That's changing. Over the past several years, children's and parents advocates have joined to develop and refine concepts of high-quality representation that emphasize positive results for families as a whole. Whether you are part of a family treatment court team or an attorney or other professionals serving children and families in the regular dependency court and the child welfare system, we hope you find this presentation helpful. So in thinking about high-quality legal representation, it's a really good idea to talk about what does typical representation around the country look like. Right now, most attorneys who represent parents and children are sole practitioners who don't have a whole lot of support from their systems. They are often not appointed until the children are removed and the court is involved, and therefore they can't really work on prevention or help a family get the support they need. They generally have high caseloads, and they're not paid very well to handle those cases. They have very little support from the system or in their offices. They don't get enough training, and there's very little quality control. And yet, most of these attorneys are working real hard. They're very good courtroom attorneys, but they don't necessarily have what they need to be the best lawyers they can be for their clients. And when I say what would a best lawyer look like, or what does high quality look like for an attorney, it's generally an attorney who has time to really get to know their clients. They have the time and the opportunity to work outside the courtroom because they know that the work that they do advocating within the agency, working on case plans, working on family time or visitation is at least as important, and I think maybe more important than the work that they do in court. They know how to advise their clients regarding how to collaborate and work within the system. They're well versed in the law and burdens of proof. They identify their clients' strengths, which is a really important thing because the clients that they're working with are often been affected by trauma. They may be living in poverty. They don't have the supports they need, and yet they love their children very much. They may have some talents that could be brought to bear in this system. They know what their children need from the system, and it's really important from a lawyer's point of view that they get to know their client's strengths. And lastly, they don't do it alone. They're part of networks. They're maybe on the National Parent Attorney Listserv, where they ask questions of their colleagues. They're engaged in their county with other lawyers. They try to get the support that they need in this very difficult work. As I mentioned earlier, I'm one of the co-leads in the Family Justice Initiative, where we really focus on what is high-quality legal representation. And for those of you who are working in family treatment court, these practice approaches may already be part of the way you are doing business. Unfortunately, that's not true everywhere, but hopefully in your treatment court it is. So part of the FJI's mission, as I mentioned, is that all children and all parents deserve access to high-quality legal representation. And we came up with what we call the attributes of high-quality representation to try to guide both parents' attorneys and children's attorneys as they're working through doing the best work they can do. And part of the attributes is that we set out 3 fundamental principles. The first is that all children and all parents have a right to counsel. And unfortunately, in too many places, that's not true. There is not either a statutory or case law right to counsel, but we believe that all children and all parents deserve that. We also believe that children must be parties to their proceeding, and that unfortunately, right now, children and parents throughout the country don't consistently have a high quality representation they need, but it should be their right, and we are working to change that. Secondly, lawyers need to be lawyers. First and foremost, children's attorneys and parents' attorneys in child welfare proceedings are lawyers who have ethical duties to their clients and to the administration of justice in an adversarial system. For those of you who aren't lawyers, sometimes when lawyers are acting like lawyers, maybe they get a little bit argumentative or they ask some questions that you don't like. It may feel uncomfortable. It may feel non-collaborative, But those lawyers are actually living up to their ethical duties. They have a duty to their client. So while child welfare proceedings are often characterized as more informal or collaborative, while there may be instances where clients' goals can be achieved through negotiation and cooperation, attorneys for parents and children must always remember their ethical duties in this adversarial system, including their professional obligation of competency and diligence. Other system actors, including judges and court administrators, also must not forget that children's and parents' attorneys have ethical duties to their clients, which are paramount to cost savings and are a cornerstone of the legal system. Some of those duties include advocating for the wishes of the client, even when a client does not do or say what the attorney advises, and having a relationship with a client that's based on confidentiality, so the attorney can't tell other stakeholders what the client has shared. But lawyers also play a counselor at law role, and to me this is really, really important for people to understand. Lawyers spend a lot of time counseling clients, both in child welfare and outside, so that clients understand what all of their choices are. And when they make a well-informed decision, it's not really up to the lawyer to decide whether it was a good decision or not a good decision. It's up to the lawyer to advocate for that client and what they want. Sometimes non-attorneys don't understand that a lawyer's role is to advocate for the client, even if that is not what the lawyer believes is best. Understanding this is an important step towards team cohesiveness and respect. And then finally, we need to prioritize quality. There needs to be a commitment that all children and parents have access to high quality, which is what we define within the attributes of high quality representation. In the document, The Attributes of High Quality Legal Representation, we've set out both attributes for the individual attorney and for the system. As you can see on this slide, there are 4 individual attributes: legal advocacy, out-of-court advocacy, cultural humility, and scope of representation. While all of these are important, I really want to highlight the out-of-court advocacy because, again, that's the place where really great attorneys who are living up to this high-quality standard can shine. It means engaging and knowing the clients, understanding their trauma history, and meeting and communicating regularly with the client well before any court hearings. Being an advocate outside the courtroom means that we're not going to do what so many lawyers are pressured to do, which is to meet with clients in the hallway of the courthouse and make decisions right away. Rather, you get to know them, you get to go to case planning meetings, and you really view the case with a sense of urgency, attending all of these meetings and counseling your client. The out-of-court advocacy goes a long way to ensuring the outcomes that your clients would want. And then we've set out these system attributes. These are the ways that the systems, the court improvement programs, the counties, or your judicial districts ensure that the lawyers who are representing parents and children have what they need. So you can see on the slide again that we have 6 system attributes: caseload and compensation, interdisciplinary or multidisciplinary practice model, diversity and cultural humility, timing of appointment, support and oversight, accountability, and use of data. All of these systemic attributes are incredibly important. And we have on the Family Justice Initiative website how-to guides about each of these attributes. And in these guides, there are examples of jurisdictions that are doing a particularly great job on all of these. As you can see, I highlighted the interdisciplinary or multidisciplinary practice model, which I'll be talking about even a little bit more later in this presentation. But there are a number of jurisdictions in almost half of our states where lawyers are paired with social workers and people with lived experience serving in mentor roles. And in this approach, holistic approach, they're able to wrap around the client and their family and ensure best outcomes. I would like to encourage your family treatment team to review our handout guide on the attributes of high quality legal representation, which are on the FJI website. And if your entire team becomes familiar with and agrees with the fundamental principles and attributes, you'll strengthen your cohesion and mutual respect within your multidisciplinary team. If you have any questions about any of these attributes or anything else I'm talking about, of course, please reach out. I'd be happy to talk about it. Now that we've talked a little bit about what high quality representation looks like, I'd like to talk a little bit about legal advocacy and an approach that can support the goal of families. My colleagues at the Center for Family Representation in New York have termed this approach the Cornerstone advocacy model, which supports family reunification by devoting intensive advocacy during the first 60 days of the case. To me, this is a really important construct because lawyers for parents and lawyers for children can focus on these 4 cornerstones at the beginning of the case and throughout the life of the case to keep a very tight focus on the important things that need to happen to make reunification happen for a family. The first cornerstone is placement. Attorneys have a really important role in advocating for placement arrangements that support a child's attachment to the parent and maintaining other supportive connections, including with their siblings, their relatives, close friends, their school, their language, their culture, and their neighborhood. A lawyer, right from the very beginning, can work with the child welfare agency to ensure that children are placed close to the parents, hopefully with kinship or fictive kin, and that the child is comfortable in the placement. The lawyer can also advocate that the resource parents get to know the parents. They could have comfort calls, they could engage in icebreaker meetings, and they can really work hard to ensure that this placement is as supportive of the family, of the child's needs, of the parents' needs as possible. The next cornerstone that I really, really love is the visitation, or what we often are referring to now as family time. This is my very favorite of the cornerstones because research shows that frequent and quality contact is the best indicator of successful reunification. You want to advocate for arrangements that, consistent with child safety, of course, are unsupervised. They're in child-friendly places. They are conducive to parent-child interaction and engagement, and they are as frequent and as long as possible, and that they are organized around activities that reflect the routines and the culture of this family. The next cornerstone is services, and that means that attorneys can advocate for services that match the identified needs and strengths of the clients. All too often, child welfare agencies choose from a formulaic menu of services and make referrals for parents and children that don't really fit their needs. Often, child welfare social workers refer families to services that are close by or familiar. This results in service referrals that may not really reflect a family's strength and may be ill-suited to a parent or child who may create unnecessary demands on a parent who must attend programs, court appearances, and visits. Poor or inappropriate services lose legitimacy for parents and can cause them to disengage or just fail to comply. And we've observed many times that in family treatment courts, that when parents receive the services that are meaningful to them and address the goals that matter to them, they are more engaged and motivated in treatment and recovery services. And finally, conferences. These are out-of-court meetings that are called all different things in all different jurisdictions, but it's really important that attorneys or members of their interdisciplinary legal team participate in these meetings. They provide opportunities for parents and older youth to meaningfully participate in case planning, and you can capitalize on sort of a national trend that's becoming a child welfare norm, we hope, family-centered child welfare practice. Many states are adopting models where child welfare-involved families participate directly in safety and service planning, If that's not happening where you are, please go to the Child Welfare Agency and help them understand what it would mean to be more family focused and strengths based. The conferences, sometimes called family team meetings, family group decision making, they allow your clients, both parents and children, to sit with child welfare workers, investigators, social workers, and other service providers to help make important decisions about their lives. It's super important that parents and children's attorneys participate in the meetings to ensure that the plans that are formed are really appropriate for them and are doable. Now I'm going to talk about a model of representation that we call interdisciplinary or multidisciplinary legal representation. This model is a model that works for representing both parents or children and youth, and it leverages having a multidisciplinary group of professionals providing holistic representation for the client. The multidisciplinary team should include a lawyer, a social worker, and a person with lived experience. That person might be called a parent mentor, a parent ally, a peer mentor, a youth ambassador, or a youth who graduated from the system, is an alum of the system, and is working for the legal team. Other members of the team could include a paralegal, other lawyers that have specialization in education law, housing law, immigration law, investigators, and other support staff. But those key members of the team, the lawyer, the social worker, and the person with lived experience, really wrap around the client, provide holistic representation, interface with the agency, and each one of those team members have an important role to play in providing the representation. In many places, this interdisciplinary or multidisciplinary team is appointed very early in the case. Again, an element of high quality representation. The lawyers could be appointed as soon as a removal happens, so that the lawyer has time to meet with their client, whether it's the parent or the child, to provide the most effective representation at the beginning of the case. The whole team can be involved with those early meetings with the client and also with going to court for the very first hearing. Another key element of the interdisciplinary model is that it's adaptable to different settings and different kinds of jurisdictions. So in New York City, for example, independent legal offices provide the representation for parents using the multidisciplinary team. And in each borough of the city, a different ILO, independent legal office, represents. Whereas in Colorado and Washington and Oregon, there are statewide systems that work with contractors who are lawyers and contractors who are social workers, who work right alongside the people with lived experience. The model is working very effectively in any kind of jurisdiction. The key is just putting together this interdisciplinary team where each person has their own role in the holistic representation, but they work together as a team to support their client. So I just want to highlight a couple of places where this interdisciplinary model is working besides New York City, and one of those places is Washington State. Many of you have probably heard about the excellent representation that occurs in Washington through the Parent Representation Program in the Office of Public Defense. And as I mentioned earlier, the Office of Public Defense is a partner in the Family Justice Initiative. Throughout the state, they have training for attorneys. They have access to expert witnesses and social workers. They work very closely with parent mentors, people with lived experience. And the really incredible thing about Washington is that they piloted this program with caseload standards, with training, with all of the supports in 3 counties. And over the course of many years, there have been multiple evaluations to show that this model of representation for parents leads to speedier permanency and better outcomes overall for the family. And so over the course of years, the legislature has allocated money so that this high quality representation model is now in every county of Washington State. Colorado is another statewide system that's designed looking at the Washington model. In Colorado, as you'll learn during our cafe conversation, there's a statewide office, one for parent representation, one for children's representation. The statewide office has support built in for the contract lawyers. So there's a director of training, and there's someone that helps with appeals, and there's a social work supervisor. And there is a whole staff that supports the lawyers around the state. Because of the central office, there is an oversight system so that if lawyers need assistance, they can reach out to the office, get the assistance, and the office can provide the oversight and the accountability to ensure high quality representation. Other states like Oregon, Louisiana, New Mexico, California, Massachusetts, Pennsylvania, Washington, D.C., and others are using social workers and peer mentors as part of a legal team. This is a growing practice, which has been given a strong boost in the last few weeks when the Children's Bureau changed its policy to now allow states to use $4 for all members of this team. We are in an excellent period where the Children's Bureau and states across the country are understanding the importance of high-quality legal representation to ensure better permanency outcomes, system savings, and all-around improved quality of child welfare experience for families. As I mentioned, in Washington state, there have been a number of evaluations that have demonstrated that high-quality legal representation for parents results in speedier time to permanency, including reunification. In a very recent study, a 2019 study in New York City, as I mentioned, there are 5 providers of parent representation in New York City, and they're all interdisciplinary law offices. There was a study that showed that in these interdisciplinary law offices, youth spent 4 fewer months in foster care, and they were 104% more likely to be placed with relative caregivers. The study used a quasi-experimental approach and looked at data from 9,582 families, which was equivalent to 18,288 children. So as you can tell, this was one of the largest studies we've seen in this area. And the children were in foster care from 2007 to 2014. And it compared the outcomes related to families who were assigned to one of these ILOs to those represented by panel attorneys. And one thing that was really important about this is that the panel attorneys were seasoned, very strong attorneys. And yet, when the attorneys had a team, an interdisciplinary team, they were able to improve the outcomes. Pairing quality counsel with specialized social workers and advocates has also shown dramatic results in Colorado. According to a program evaluation conducted by professors at the Metropolitan State University of Denver's social work program, parents who are assigned a lawyer and a social worker have a 22% higher chance of family reunification when compared to similar high-risk cases in the same county. In El Paso County, one of Colorado's largest, children whose parents had interdisciplinary representation achieved reunification at over twice the rate of the state and county averages in 2017 and 2018. Though the initial program evaluation includes only closed case data for 207 children over 2 years, this way of practicing is promising for Colorado's families and reflects the positive outcomes that other states have seen. So as many of you know, at the end of 2018, the Children's Bureau changed its policy manual to allow states to claim federal matching funds through 4E of the Social Security Act to help pay the costs of attorneys for parents and children, and as of April 20th, 2020, the cost of the entire multidisciplinary team representing children and their parents in child welfare proceedings. To receive the $4E, the program providing representation for parents and children must enter into an agreement with the state agency administering the Title IV-E plan, so generally the state child welfare agency. So in my mind, this is one of the biggest philosophical and financial wins in recent history in child welfare. This change demonstrates the Children's Bureau's understanding and appreciation for the idea that paying for high-quality, multidisciplinary representation for parents and children leads to outcomes that we all want for our families. So far, there's about 7 or 8 states that are taking advantage of the opportunity to use federal resources to improve representation. Please let me know if your state is interested. I am happy to talk with any of you. It is really an important change in our system and an incredible way, especially now as our economy is in a downturn, to be able to bring in some extra resources to pay the costs of high quality representation. So what does this mean for attorneys serving families affected by parental substance use? I want to spend a few minutes here talking about redefining the win for parents attorneys and what this means for representing parents affected by substance use disorders. Cases involving parental substance use disorders pose unique challenges for all professionals, including legal professionals. There are competing time clocks, as all of you know. First, the various timetables, including the ASFA clock, which limits the time parents have to achieve permanency, may conflict with recovery timelines. Recovery is a lifetime process that can include episodes of lapse or relapse. The child development time clock, which can vary according to the age of the child, may also compete since children experience time differently. Exposure to substances, trauma, and loss and separation can negatively impact child development. For families affected by substance use disorders, these timelines create extraordinary pressure. Time is child welfare system's biggest challenge and has been since the beginning and the passage of the Adoption and Safe Families Act in 1997 and the advent of reasonable efforts requirements way before 1997. The ASFA timelines do not reflect what we know about parent-child relationships, recovery, and trauma. They do not reflect what we know about treatment and recovery and do not reflect the contextual factors that are directly relevant to successful reunification, such as the availability of quality services and treatment and a family's ability to access services in a timely and effective manner. As an attorney for a parent or child, if your case involves a parent who is in recovery, advocate to your child welfare agency that this is a compelling reason for them to not file a TPR petition. Sometimes families need a little longer to heal, but being together is really essential for the best outcomes for those children. Reasonable efforts for families affected by substance use disorders would most certainly require substance use treatment and recovery support. Unfortunately, many child welfare and legal professionals lack a solid understanding of what constitutes quality treatment and whether such treatment is available in their community. The same can be said for parent education. Substance use disorders have a profound effect on parenting capacity, family dynamics, and the parent-child relationship. These issues would require a solid understanding of what types of parenting curricula are most effective for this population. And when thinking about the co-occurrence of trauma with substance use disorders, will require a trauma-informed approach by the lawyers and everyone else in the system. Guilt and shame and the stigma of addiction will also make engagement and gaining trust with clients more challenging. A lack of understanding about addiction will require that all court professionals receive training on understanding substance abuse, substance use, and trauma and co-occurring issues and its effect on adults and children. For those of you who are attorneys, your legal training focused on developing excellent investigatory and litigation skills. In practice, you are likely to devote those skills to trials, discovery, and motions. The good attorneys, however, know that their work outside the courtroom is just as important as in-court advocacy, as we've discussed earlier. The best attorneys also understand that the best way to accomplish their clients' goals is to work with other professionals and parties involved in the case in a cooperative and ethical manner. This could mean that they attend case planning meetings with child welfare and ensure that services are matched with identified needs, yet workable for the client. They have a solid understanding of quality treatment and what is available in the community and encourage referrals to those services. With the clients, the best attorneys encourage the client to comply with appropriate services, help them prioritize case plan requirements, help the client decide which services they can realistically participate in, and help them problem solve any barriers and challenges. They emphasize the importance of frequent family time in child-friendly places to the client and agency, and ensure the agency schedules those visits, helping with transportation and supporting the parent during the visits. The lawyer ensures the child welfare agency never uses family time as a punishment. Taking away family time is punishment for the child and negatively impacts the parent-child connection. Of course, if a particular visit cannot occur safely, the agency can reschedule it for a time when the parent can be emotionally present and appropriate with the child. The attorney reminds the child welfare agency that reasonable efforts when necessary, and enlists the court when needed, and works with the client to comply with the efforts. The best attorneys see winning a little bit differently. A win is understanding each individual case and what their clients need, and advocating zealously in court for those services to meet those needs. A win in dependency court is getting the family linked to quality services as quickly as possible, so that the children can return home to a healthy and safe environment and never come back to the attention of child welfare. A win is connecting clients with quality services that are evidence-based, gender-responsive, trauma-informed, and family-centered, and readily available. A win is applying your best skills of being a counselor at law in situations where there emerges a clear tension between the client's long-term and short-term goals. During these one-on-one conversations with the client, the attorney may recommend engaging in treatment or in the family treatment program that would serve the client's long-term goals, even though those activities may cut against the client's short-term interests. It may mean that getting the child home takes a little extra time, but that child stays home safely and never returns to the system. If the client decides not to follow your advice, you then know how to advocate for his or her wishes. But it's important that you share your best thinking so your client can make an informed decision. You can still deliver zealous advocacy without being argumentative and always having to go to trial. You can be collaborative without having to sell out your client and ignore your ethical duties. Parents and children's attorneys are critical not only in serving their clients' interests, but also for the success of a family treatment court and achieving its mission shared across multiple agencies and systems. Engaging attorneys remains one of the most important things a family treatment court can do to ensure its success. Family treatment courts are still court programs where due process must be protected, and they serve as gatekeepers and can be the strongest advocates for the program. So what can family treatment court teams do to ensure quality legal representation is a successful part of a cross-agency collaboration, particularly between parent attorneys and child welfare? Here are a few next steps. Your team must involve attorneys from the very beginning. That means full engagement and participation in the planning and design or redesign efforts. The lawyer's input and feedback ensures that all aspects of the program protect due process and parent participation. You can discuss and clarify roles and responsibilities. Everyone on the team should understand that parent attorneys must balance their role as team members with their professional and ethical obligations to their clients. Attorneys should always understand that their participation in staffing and session is critical for the protection of their client, but also for the team's success. Ensure that attorneys have a solid awareness and understanding of the Family Treatment Court program. Today, I made the case for why high-quality legal representation makes a huge difference in the lives of families affected by parental substance use disorder. These clients are some of the most vulnerable in our communities, and they deserve the best quality and best professionalism of all of the people who are involved in working with their families, including the legal professionals. One thing we have learned is that the best attorneys in these courts do not practice in isolation, nor do they see things in isolation. Their advocacy is client-focused and family-centered and zealous and collaborative. We are all bound by a shared vision, which can only be achieved when we work together. An increasing number of attorneys in courts are realizing that the best way to accomplish a client's desires is to advocate zealously, work collaboratively, and work within a team with social workers and people with lived experience. When we all work together, families realize for themselves that they are very much worth fighting for. Please feel free to download our team discussion guide and our action guide. We hope that you found this presentation helpful, and you can find more resources at our websites for Children and Family Futures, the ABA, and the Family Justice Initiative. Thank you again for joining us.
Thank you for listening to our webinar presentation. To further your learning, please download the webinar discussion guide, which provides questions for your team to explore and next steps and resources to move your team forward. Again, for more information about Children and Family Futures, the Learning Academy, and the FTC TTA program, please visit our website, our Family Drug Court blog, or email us. Thank you, and we hope to see you again here at the Family Drug Court Learning Academy.